Welcome to One Room at a Time. I'm your host, Atticus LeBlanc, founder and CEO of PadSplit, the country's largest co-living marketplace, where I've spent more than 2 decades in affordable housing as a property owner, developer, and now an entrepreneur. This show brings together some of the brightest minds in housing to talk about how we can create real solutions to solve the housing crisis. We've got a bonus episode for you today. One of the first questions I get anytime someone wants to know about co-living or shared housing is whether or not it's legal in their area. If you followed me on LinkedIn for any amount of time, you probably heard me complain about how the term family is defined by a local jurisdiction, often in very outdated ways. And at PadSplit, we sometimes find ourselves battling these outdated definitions in order to make sure that American workers can actually live in their communities. Several states have been moving proactively to make sure occupancy is based on health and safety rather than simply blood relationship. And most recently, we saw the proposed Golden Girls bill in Pennsylvania that is currently being discussed. This policy has far-reaching implications for co-living, affordable housing, and constitutional law. So joining me today to talk about these issues is David Deerson. He's an attorney in the Pacific Legal Foundation's property rights practice, where he joined in 2018. David has been involved in multiple high-profile cases at PLF. Most notably, he served as a member of the litigation team for Tyler versus Hennepin County, in which the U.S. Supreme Court unanimously ruled that home equity theft violates the Fifth Amendment's takings clause. David, thank you for joining us today.
Absolutely, Atticus. Thanks very much for having me.
Well, before we get too much into zoning policy and legal history, as much as I love those topics, tell us a little bit more about the history of Pacific Legal Foundation and your experience specifically and how you got there.
Sure. Pacific Legal Foundation is a nonprofit public interest law firm that litigates to defend individual rights and combat government overreach. So in short, we sue the government, and we've been doing it quite successfully since the early 1970s. We've been around for over 50 years. And the name shouldn't fool people, although it's the Pacific Legal Foundation. It was founded in California, and it's headquartered in Sacramento. It is a national practice. We have attorneys who are working all over the country, and we take cases all over the country at the local, state, and federal level. We have several different practice areas, sort of seeking to advance every aspect of individual rights. One of our flagship areas is and always has been property rights, which is where I work. I've always been interested in individual liberty. I've always felt that often the best solutions come from people acting privately in their own interests, cooperating with others, or competing with others, which redounds to the public interest. And so I was sort of looking at doing this kind of public interest legal work as I entered law school in Vanderbilt. And I was very fortunate to be hired by Pacific Legal Foundation as my first gig out of school.
Awesome. And so you guys are typically in property rights, you said, for individual liberties, but could be anything over that 50-plus year period?
Yeah, I mean, we also focus a lot on separation of powers, which is basically forcing the federal government to play by its own rules. We also do a lot of work in equal protection and individual opportunity, whether that's economic liberty, your freedom to start a business, or it's your freedom not to be discriminated against by the government on the basis of race, sex, or any other characteristic. First Amendment freedoms, really anything you can think of.
Got it. Well, what we're going to get into today, hopefully a little bit, is, and I'd love to hear you share or wax poetic more about just zoning history and definition of family. And obviously it gets pretty complicated. So maybe level set for the audience who may not be as familiar with some of the legal history around occupancy versus family and why anybody even talks about this, but me certainly.
Sure. I mean, it starts at really the beginning of the 20th century. You've got industrialization. Cities are starting to get bigger and more crowded, and they're looking for ways to essentially reduce the transaction costs of going after land uses that pose a nuisance. If the local government has to kind of take every single person who's using their land in a way that's a nuisance to court, it's going to be very expensive, very inefficient. So they come up with this idea that they're going to have these comprehensive zoning plans. And it's essentially the origin of modern zoning as most people know it, where they're separating out different categories of use. They're not just separating residential from commercial and industrial, but they're even distinguishing among different types of residential, like single-family residential, duplexes, all the way up to apartment buildings. And the first time this really gets tested at the United States Supreme Court level is in a case called Euclid versus Ambler Realty Co. From Euclid, Ohio. And what I think a lot of people might be surprised to hear is, really they were one vote away from having these kind of modern zoning schemes be declared per se unconstitutional. That's really what was at issue. In the Euclid case, it might have gone the other way and held that zoning as such is a violation of due process, violating people's property rights. They didn't go that way. They decided that it's within the government's power to lay out these zones, separate these different kinds of uses, as long as they had some substantial relationship to, a health, safety, and welfare consideration. Now, of course, over the last 100 years exactly, by the way, the Euclid case was 1926,
right? Yep.
And here we are in 2026. Over the last 100 years, unfortunately, in a lot of jurisdictions, including at the federal level, that test that zoning has to be substantially related to some legitimate health, safety, or welfare interest has really been weakened. But that's sort of a bigger story than just the family issue. Looking back at the family issue in particular, it occurs to one that if you're going to distinguish between, let's say, single-family residential areas, multifamily residential areas, places where apartment complexes are allowed, you might need some sort of definition of what a family is. And so local jurisdictions who primarily are that's the level at which zoning is being designed and enforced. You've got states that are enabling their local municipalities to design and enforce these zoning codes. So you see local jurisdictions coming up with all kinds of different ways to define a family. And some of them, as we know, have chosen to define it very, very narrowly by blood relation only, or marriage or adoption. And that, too, gets tested at the United States Supreme Court about 50 years later. And really, since the 1920s, it's one of the first cases where the Supreme Court takes another look at zoning policies. And that's in the case of Belle Terre versus Village of Boraas. Although I'll tell you, I had a judge in 10th Circuit Court who was of Italian descent, and he insisted that it should be Belle Terre.
Village of Belle Terre versus Boraas.
Yeah, Belle Terre. Yeah, I'm still. I don't want to go too far in butchering the nice Italian pronunciation, but I usually hear it called Belle Terre. And that case involved a very, very, very small village of only about 700 inhabitants, and it involved their zoning regulations that limited the entire village to single-family residential use. And it defined the family very narrowly by blood relation. And the plaintiff there was a landlord who wanted to rent to unrelated tenants. The Supreme Court took a look at it and ultimately decided there was no constitutional problem with this definition of family at all. The government was free to basically to discriminate against people in their living situations on the basis of their relational status. A couple of years after Belle Terre, you get Moore versus East Cleveland. And there the family was defined even more narrowly because it wasn't just blood relations, but it was close blood relations, such that the plaintiffs in that case were two different cousins who were living with their grandmother. But that cousin relationship was not close enough under the local ordinance to count as a family. And so this comes just 3 years after Belle Terre, and the Supreme Court sort of puts on the brakes and says, well, hold on, there is a limit to the government's power to define family. We don't think it should be able to, what they say, go into the family and slice up, to prevent two cousins from living together. So that's one quick stop on sort of the reach of Belle Terre. Yeah, they can limit you to family, but they can't limit, the degree of relationship within what might be thought of as a traditional blood-related family. I think the next Supreme Court case that's really important to consider here is Cleburne Living Center versus Cleburne, Texas. And that case didn't actually involve family members living together at all, but it did involve an ordinance that would have prevented a group home for mentally disabled people, basically under the reasoning that, well, we only allow families here, and the people in this group home would not be a family. And that case is really interesting and really important, I think, for a few reasons. The Fifth Circuit Court of Appeals in that case had decided that mental disability was a suspect class, which in equal protection law means that the government has to have a really, really good justification for regulations that discriminate against the mentally disabled. The Supreme Court actually disagreed with that and said, no, we don't think that this meets the legal standard of a suspect class. The government's justification doesn't have to be any better than it usually is. However, they do need to have a rational basis for imposing these zoning regulations. And in a way, this goes back all the way back to the Euclid case, where the court asked, look, is there really a substantial relationship here between some real health, safety, and welfare concern and the government's decision to prevent this group home? And the court could not find one. And so it ruled that the city's family ordinance could not be used in that instance to prohibit the group home from being there. And that's sort of, from 1926 to 1985, that's kind of the whole bucket of Supreme Court cases, at least, that have looked at this issue.
Got it. Yeah, so over 40 years later now, but it's something to highlight here too. We had Alex Horowitz from Pew Research Center on the podcast recently talking about just what was happening in America around that time and the suburbanization movements. In 1974, I think, is particularly interesting as you talk about the village of Belle Terre versus Boraas case, in that it was just accepted. Everybody was going to, at least culturally, picket fence, and you're in a suburban neighborhood, and this is just going to be the future from here on out, which clearly has not been the case. And now, with the affordable housing crisis that we're living through, you can really see the impacts of that mentality. But there was one person, regardless if you know anything about the Supreme Court, I suspect anyone who's been in American elementary school probably remembers one particular name, who was the dissent on that 1974 case, which was Thurgood Marshall. And curious, based on what you've told us about Euclid in 1926 or some of those future cases, tell us a little bit more about Thurgood Marshall's dissent and what he said versus how that relates to where we are in 2026.
Yeah, absolutely. It's a fabulous dissent, and maybe to give you a preview, if it's not already obvious, of where I come from at this issue, I think it's a very prescient dissent, and it's one that I think eventually is going to win the day, and that I'm working towards vindicating. He starts by basically accepting what the majority identifies as the genuine government interest in these policies. The Belle Terre majority, written by Justice Douglas, has this flowery, almost saccharine language about how it's within the government's interests to ensure. They don't use the white picket fence terminology, but that's what they're thinking of. They say something like yards are wide and cars few, and children laughing as they swing on tires. This kind of imagery. And Marshall, I think, cleverly sort of accepts this. It doesn't challenge that notion, which, as you point out, has become such a popular notion in the mid-1970s with suburbanization. But what he does say is, look, there's more at stake here than the majority is willing to let on. And in particular, there are really important rights of association that are at stake. And the majority had rejected any notion that there was some kind of constitutional right of association that was at play here. But what the majority had been thinking of when it comes to right of association is the First Amendment, which protects rights of expressive association. So you get a lot of cases in the middle of the 20th century in which the government is sort of trying to regulate political groups like the NAACP, for example. And the courts say, well, you can't regulate them in this manner because they've come together for some expressive activity, and that's a clear First Amendment protected activity. And that's what the majority had in mind when it rejected this idea of associational rights. But Thurgood Marshall pointed out that the right of association goes beyond just expressive activity, and that there's actually really important intimate associations that people form on their way to, pursuing happiness, on their way to living their lives in the manner that they best see fit, and that those are not only deserving of constitutional protection, but have already been given constitutional protection in the United States Supreme Court. So he also talks about how this is especially true when we're talking about association inside the home, which in our tradition of Anglo-American law is really the one place where government is not supposed to be able to come in and intrude upon. And, Justice Douglas, who wrote the majority in Belle Terre, it was kind of surprising because just a year or two earlier, he had written a case called Moreno versus the Department of Agriculture, in which there was basically a food stamp style welfare program run by the Department of Agriculture, but you could only apply for the benefits on a family basis. And Justice Douglas understood that there was a problem here when the family was too narrowly defined. And he said, actually, people who are banding together for economic or social reasons is an important part of the American tradition, and that at least for the purposes of obtaining these welfare benefits, they're no less a family than, what we might think of as the nuclear family, mom, dad, brother, sister. So he understood that principle just a few years earlier, but for some reason in the Belle Terre case, he sort of forgets it or he does an about face. And Justice Marshall in his dissent really sort of calls him out for that by quoting him directly in the Moreno case, where he says the freedom of association encompasses the right to invite the stranger into one's home, not only for economic reasons, but also for important social reasons, quality of intimate associations, how you want to structure your life in your home. It is just a really vital aspect of liberty that Thurgood Marshall believes the Constitution protects.
Sure. Well, and for those who are less familiar, at least offhand, with the First Amendment, it's not just freedom of speech and freedom of expression, but yeah, that freedom of association, I think, was really an important part of it. And then also, correct me if I'm wrong, I think what Thurgood Marshall doubles down on in that case is that it's totally rational for a city to have a zoning policy or definition that regulates unrelated people the same as related people, but you can't have a scenario where you can allow an unlimited number of related persons, but then limit the number of unrelated people who may have an economic need or really any reason whatsoever that they choose to associate together. Is that a decent summation?
Yeah, that's exactly right. I mean, he basically makes this move that the Euclid court says that you're supposed to make, and that, the Cleburne case that I talked about earlier actually does make. Marshall tries to make this move, which is not just accepting the government's justification on a sort of deferential manner and rubber stamping it, but actually looking into, well, what are we doing here? You're telling me that, in order to create this suburban dream that you want, you have to make sure that you'll never have three unrelated people living together. Meanwhile, there's nothing stopping 10 third cousins from living together. What is really the rational connection there? There's no evidence that unrelated people are more likely to, I don't know, have traffic violations or noise complaints or any other kind of nuisance. It's just sort of based on often a naked stereotype, I think, of the kinds of people that have to that choose to live together without a family relationship status.
Yeah. And one of my favorite exclusions that we still see today in city family definitions is that Oh, well, unrelateds are prohibited except if they're domestic servants working and living on the property, and those are unlimited whatsoever. And it's as you talk about whether it's Euclid in 1926 or Belle Terre and Justice Douglas's description of and I remember what you were quoting about the where wides or where lawns are wide and cars are few. And I would be remiss if I didn't take this opportunity to point out one of the quotes, famous or infamous quotes from 1926, which I think really everyone in America needs to know, which was from Justice George Sutherland, that described apartment house as a mere parasite constructed in order to take advantage of the open spaces and attractive surroundings created by the residential character of the district. Which is it's crazy to hear looking back, talking about things that don't age particularly well. But even now, and I don't know if you hear this in cases, but I hear it brought up regularly, whether in city council or neighborhood meetings, talking about the character. They have to protect the character of single family neighborhoods, while also protecting the rights for people to have domestic servants
Right.
on the property.
Well, it's hard to find good help these days.
But it is mind-boggling in some ways that we're still having these conversations here in 2026. And so now that we've kind of set the stage, help us understand maybe what's been happening since Belle Terre and where you guys at Pacific Legal Foundation have been involved in some of these specific challenges, whether it's protecting the First Amendment protections of freedom of association or due process or the Equal Protections Clause as well, all of which are in the Constitution.
Yeah, absolutely. And first, I just want to comment on what you just said. I think it's exactly right. I think there are these sort of openly classist undertones to a lot of these decisions, and we do see the enforcement often of these family definitions being applied in a way that certainly looks on its face to have a disparate impact on young people, on students, on people who are recently arrived in the area, on immigrants. And we see those, not only in sort of the concerns that are raised at the city council meetings, but also when we pull the public records requests, we sort of see that pattern in the enforcement action too. To answer your question about how things have evolved since Belle Terre, from the moment that decision was issued, the kind of legal academy protested, and there was sort of a slew of activity suggesting that the case had been wrongly decided. And then, of course, you had those two subsequent Supreme Court cases, the Moore versus East Cleveland and the Cleburne case, which at least sort of, they didn't overturn Belle Terre, but they sort of put the brakes on this notion that the government has unlimited power to say who's allowed to live where. And there have also been, state court cases that have looked at the same issue. And sometimes under the state constitution, as opposed to looking at it under the federal constitution. Now, different states treat these kind of things in very different ways. So a lot of states have basically decided that, the liberty protections in our state constitution don't go any further than the protections in the federal constitution, that while they're separate documents and they govern separate jurisdictions, ultimately, substantively, they're coextensive. So you certainly had many states who have looked at the issue and said, well, Belle Terre decided this as a matter of federal law, and we're just going to basically be in lockstep with that when we're interpreting our state constitutions. Other states hold their constitutions to a different and higher standard. And so you've had states like New Jersey and California in particular, which have decided under their state constitutions that it does violate people's rights to discriminate against them in their living situation on the basis of their family relationship status. You've also got Rhode Island, New York, and Michigan with similar decisions, although a little bit weaker or not as high a level. But ultimately, there are 27 states by my last count, which haven't looked at the issue at all, and so that's sort of an open battleground for people to look into whether the state constitutions are interpreted to be substantively different, to be more protective than the federal constitution. There's actually a live issue right now in Ohio. In fact, just yesterday at the Ohio Supreme Court, a case was heard that looks at this issue directly and tries to decide whether under the Ohio Constitution it's legitimate to impose such a narrow definition of family. Pacific Legal Foundation has also been active in this issue. We have a case right now in the 10th Circuit out of Shawnee, Kansas, where we're arguing that these kinds of anti-cohabitation laws, anti-co-living laws, violate that freedom of association that Justice Marshall was talking about. And in kind of a separate line of cases that didn't have to do with zoning, starting in the 1980s, the Supreme Court made explicit what Justice Marshall had pointed out about the difference between expressive association and personal, intimate association. And they explicitly created this doctrine of intimate association, as they called it. And they said that the government can't go in and regulate associations that are, small, exclusive, private, that by their nature should not be subject to government regulations. They sort of create a spectrum where on the most extreme side, the most protected is that narrowly defined family. And on the other side, the least protected are things like large business enterprises or, big membership groups like the Rotary Club with national memberships. And there's a really, really strong argument that people who are choosing to live together, to share the burdens of life and the joys of life, who are sleeping in rooms right next to each other, trusting each other with their safety, with possession of their property, that's about as close as you can get on that spectrum to the narrowly defined family, and that therefore they're deserving of serious constitutional protection under that doctrine of intimate association, which Justice Marshall really predicted 10 years before the Supreme Court made it explicit. So that's the argument that we're bringing in our case, Homeroom versus City of Shawnee. One of our clients there is Homeroom, which are friends of yours at PadSplit, a startup to facilitate co-living situations. Another of our clients there is Val French. Val owns her home with her husband, and they live there together with their 2 adult sons. And one of the sons invited his girlfriend to come live in the home. Now, once you have that girlfriend in there, who's not related
Sure.
to anybody else in the household, which, for the most part is a good thing, all of a sudden that family is in violation of the law. That living situation is illegal because, this girlfriend who had fallen on hard times is invited into the home to live as part of the family. And it certainly doesn't seem that there's any legitimate reason the government would have to prevent families like Val French's from living together in the same home, particularly a home that they own. It's a violation of their property rights and of their intimate associational rights. So that's sort of on the
when do you
litigation
expect,
side.
Yeah, when do you expect like that there's going to be rulings in these cases? I know these legal cases can sometimes take years and years.
It's a matter of some personal frustration. In our 10th Circuit case, we had oral argument in that case September 24th of 2024, and we're still waiting for a decision. So,
Oh, wow.
It's been over a year, almost about a year and a half, and we'll just continue to wait. Unfortunately, there's not often much you can do to prod the courts.
If it gives you any solace, David, it's at least obvious to the rest of us.
Yeah, right. I appreciate that. The court of public opinion matters too,
Yeah.
right? And one reason the court of public opinion, actually does matter, why that's not a throwaway comment, is that in addition to litigation in the courts, you also have the legislative battle. And that is, a democratic process where public opinion really matters.
Yeah. Yeah. I mean, on that note, so you guys have obviously been fighting some of these cases. PadSplit has fought and won or settled favorably a number of these cases, namely in Georgia, throughout Georgia, and in Florida now. We've at the same time seen a number of states who have just said outright, we're going to preempt any of these local laws and require any occupancy governance to be based on health and safety, and it cannot be on any sort of familial relationship. Colorado comes to mind. Oregon, I think Washington State has passed one. Texas, although it was somewhat limited. New Hampshire, and now Pennsylvania has
right.
released the Golden Girls bill. Simultaneously, you guys have released your Golden Girls model policy. So for the younger members of our audience, who are the Golden Girls? Why does that matter? And yeah, talk a little bit about just like the two ways, whether it's legal challenges or legislative, and who's going to get there first.
Yeah, so I love that name, the Golden Girls bill, because I think that's a really easy way to understand what's at stake here, the kinds of situations we're looking at. Yeah, for the younger viewers, the Golden Girls is a great old sitcom in which 4 senior citizen women who were not related to one another. Maybe there was a mother-daughter pair, but under most of these ordinances, that wouldn't be enough. They chose to live together for all kinds of reasons, for companionship, economic reasons, and they might have had some nosy neighbors in some episodes, but I think for the most part they weren't presenting too much of a nuisance. And it sort of seems crazy, I think, to most Americans that there's something illegal about that living situation simply because not all of them are related to one another. But under most of these policies, that Golden Girls situation would be illegal under their zoning codes. And so Pacific Legal Foundation has our own model policy that sort of seeks to echo some of those legislative protections to say, no, the government can't come in and impose occupancy limits that don't actually have to do with occupancy. They have to do with the status of the people using the land. One thing we like to say is that zoning, properly understood, is supposed to be about regulating land use. It's not about regulating land users. And that's one of the big, easy to understand problems with these kinds of family ordinances, is that they're not addressed to how a residence is being used. They're addressed to who is making use of the residence. And that just goes further than the government is really allowed to go in its zoning power.
Yeah, keeping those people out of my community, and it goes back to renters. We want fewer renters, and love that description about users versus use. And so we've seen some positive traction both on the legal front and now on the legislative front. Curious to know your prognosis and predictions. So 5-10 years from now, where are we going to be in the U.S. in terms of shared housing policy overall? And will we get there because of the legislative side and just changing public opinion? Or is it going to be more likely because of legal challenges?
I think it's definitely a two-pronged attack, and you can't ignore either prong. I think we're starting to see these legislative protections become more popular. So I expect to see, Pennsylvania is just the latest, but I expect and I'm hopeful to see more states, taking up some version of this Golden Girls Act. And that's really important to get those short-term is the wrong word, really, to get those immediate protections in place now. Because, in addition to all of the personal and individual legal rights that we've already discussed that are at stake, there's also just, broader housing policy. It's no secret to anybody that we're in a housing shortage nationally, and that housing affordability is a major, major problem. And what's sort of crazy is, I think those of us who are aligned with the YIMBY movement, we're often looking at ways to make it easier to construct new housing units. But here, the problem is we're not even allowed to fill all of the
Yeah.
bedrooms that already exist because there's not enough people in a family. So just as an example, in the Ohio case, just being litigated by friends of ours at the 1851 Center, which is a great nonprofit in Ohio. That case is called Havel versus City of Kent. Havel is the landlord. He's got a 6-bedroom home. And he's not allowed to rent out all 6 bedrooms unless he, can somehow find a family with exactly 6 members or whatever it is. He's not allowed to actually make the optimal capacity of the home and fill those bedrooms. Now, we've done research into this at Pacific Legal Foundation. We focused on Shawnee, Kansas, which is where we've got our case representing homeroom. And we've looked at Shawnee, and we've looked at some surrounding Kansas City suburbs. What we found is that in jurisdictions that don't have these kinds of anti-co-living laws, you've got something like a 20% increase in the rate that bedrooms are actually filled. So this is really important, right?
Sure.
I mean, that's real, getting people into bedrooms, getting people into houses, making use of the residential stock that we already have is really important in addressing the housing crisis.
I love that campaign. I think they actually ran it in Colorado, which is bedrooms are for people.
Bedrooms are for people. That's exactly right.
Right up there with Golden Girls.
Great messaging. Yeah.
But yeah, where are we going to be?
Well, that's the legislative side, and I think we're going to see more and more states adopt this. But I'm also very confident about the legal position. I happen to think that this argument about the doctrine of intimate association is very, very compelling. And essentially, the way I see the landscape is that Belle Terre has never been overturned, but this intimate association doctrine that's been developed in a separate area of law makes it really difficult to see how Belle Terre can still stand on its own merit. And, I'm excited to eventually get that 10th Circuit decision. We'll see how it comes out. But I'll tell you, at oral argument, one of the judges seemed essentially to accept that point, that it's really hard to square the Belle Terre case with all of the developments that have come in the law afterwards. And so the more of these cases that we can get up at the federal level, I think there's a good chance that the Supreme Court is going to want to take another look and potentially overturn Belle Terre, sometime in the foreseeable future. And while the legislative fixes provide a great immediate solution, of course, it's a state-by-state issue, overturning Belle Terre at the federal level would solve the issue from a constitutional floor perspective nationwide. But it would also, I think, have broader implications for the rest of zoning policy. I think part of it comes back to this thread that I'm trying to draw between a case like Euclid, which at least says that you have to have some substantial relationship between the zoning regulation and an actual legitimate health, safety, and welfare concern, and a case like Cleburne, which actually applies that kind of test, where too often it's sort of brushed aside and given a rubber stamp. I think getting this issue back before the Supreme Court might present an opportunity for the court to kind of reinvigorate that doctrine, to say, look, it's not enough to just say, hey, this regulation, we called it a zoning regulation, we put it in our zoning code, it's a local issue, just trust us. That shouldn't cut it. It wasn't supposed to cut it in Euclid. Too often it does, as a matter of course. I think getting this co-living issue up before the Supreme Court again could have those broader implications. So I'm very hopeful that we'll see both more adoption of the Golden Girls bills, and look, it's one of my personal ambitions to try to get this issue back up to the United States Supreme Court in the next 10 or so years.
Love that. We'll certainly be cheering for you and supporting you, and I know there are a lot of other nonprofits defending civil liberties that will as well, in addition to the millions of people out there right now who are renting rooms. So in the meantime, PadSplit and others will continue to fight these cases individually until we can get a Supreme Court decision or maybe some legislation across the U.S. But David, thank you so much for sharing. Man, a lot of great knowledge and tidbits here and history that I think is consolidated the cases around zoning and specifically shared housing into one straightforward explanation and what's at stake. So really appreciate your coming on. Great place to wrap up here. So yeah, thanks. And thank you for the Golden Girls model bill as well. And really excited to see the broad implications for housing policy across the board and making sure that people can actually afford to live in the communities where they work. And for our audience, you can learn more about David's work at pacificlegal.org, and we will link that and some of these other interesting cases in the show notes. And thank you, everyone, for tuning in to this bonus episode of One Room at a Time.
Thanks so much, Atticus.